Hello, and thank you for attending Diversified Administration's ACA, and more ACA webinar presented by me, Sandro Vivas, and I am the Marketing Communications Manager and ACA Specialist here at Diversified Administration. First, a disclaimer, of course. The information presented is solely for educational and informative purposes. It must not be considered legal, professional, or tax advice. Employers are advised to consult with a qualified benefits expert or an attorney. With that being said, let's get started. So, you must have heard this question more than once. Is the ACA gone for good? Did we finish with the ACA? Did the government get rid of the ACA? Well, the answer is no. The employer mandate is still in place. And again, it can only be changed by changing the law, which has not happened yet. Now, President Trump did sign an executive order in January of 2017 to minimize the burden of the ACA for individuals, not for companies, only for individuals. And what this does is bring the penalties down to zero starting in 2019. So just in case any individuals or employees ask, they are still responsible for having health insurance for 2018. And again, this executive order does not mention employers and effectively keeping the employer mandate in place, including its penalties. Also, the IRS has been sending out Letter 226J. This document lists penalties for the employer that receives it due to noncompliance and or submitted errors. Now, the IRS is sending these out for the reporting year for 2015 ACA reporting year. And of course, this is 3 years after, so we expect these to continue to be mailed out for all other reporting years. Now, the ACA, more of the same. As mentioned, the ACA, the same rules apply for 2018 that apply for 2017. There haven't been major changes in the guidelines, so basically everything remains the same. The applicable large employers, ALEs, must report. Data in 1094 and 1095 forms must be accurate and submitted on time. And again, the lack of accuracy is what actually prompting a lot of penalties that we've seen in this Letter 226J. The employers are still subject to penalties for inaccuracies, untimeliness, and noncompliance. And of course, the enforcement is up to the IRS. And of course, like mentioned, employers have been receiving Letter 226J for the 2015 reporting year. So everything is business as usual. Who must file? And again, you must be aware of this already. Applicable large employers, which are companies or control groups with 50 or more full-time or full-time equivalent employees on average in 2017. And then we have the employer must file if they have less than 50 full-time or full-time equivalent employees, but offered coverage in 2018 are self-funded. So if you have a small company that, again, doesn't reach the 50 full-time equivalent employees, you must look into the plan and see if it's self-funded. If it is, they have to report for 2018. And these numbers are for the number of employees during 2018. It's not like for the applicable large employers, in which case the previous year number of full-time and full-time equivalent employees is what determines if they have to report for the following year. So for 2018, you have to be very careful. First, you must determine if a company is part of a control group. Many HR departments work in HR, of course, and are not aware of the ownership structure that the owners have within the company and with other companies that the HR department might not be aware of. And if if companies that are supposed to be part of a control group are not reported as part of a control group, this could be a problem and generate penalties, and we just don't want that. You must also determine if a plan is fully insured or self-funded. The fully insured plan, of course, is a plan in which the insurance company is a responsible party for the medical bills, and in a self-funded plan, it is the employer who is the responsible party. The additional complication with self-funded plans is that you also have to report dependent information, which is sometimes a little bit hard to get. You must determine also if a plan complies with the MEC, minimum essential coverage, and the minimum value provisions under the ACA. You must also determine affordability by verifying if the employee's monthly contribution is 9.56% or less of the gross monthly income. We've seen that sometimes when the number are too close to the threshold, we see that if an employee loses employment, loses hours, or whatever the case may be, sometimes they can actually, the 9.56% threshold does not apply anymore to that particular employee. So you have to be very careful and advise employers about this, to be on the lookout for these changes, and to be sure that it's better err on the side of caution and try to minimize the employee's contribution in some way. You also have to indicate how affordability was determined, and there's 3 safe harbors for that. There's the rate of pay, W-2, or using the federal poverty level, or FPL. Rate of pay, quite simply, you determine the employee's gross income for the month, and then the employee's contribution for that month, and determine if that contribution is 9.56% or less of that month's income. The other way is using the W-2 form. The W-2 form has the problem that it comes out after the fact early next year. So then you'll have to look backwards into 2018 to make those calculations, and that can lend itself to error, omissions, and we just don't want to risk that. And finally, the federal poverty level. So in this case, we take the federal poverty level determined by the government. That is for 2018, $12,140 for individuals per year, which means that it's $1,011.67 per month per individual. So the affordability threshold is 9.56%. So simple calculation: if an employee's monthly contribution is $96.72 or less, you can use the FPL safe harbor. And we recommend you use it because it lends itself to less scrutiny. So that's pretty important. And again, choosing the right safe harbor is also important because, again, if the contribution is less than 96.72%, you definitely want that employer to use the FPL, the federal poverty level safe harbor. Continue with being very careful. You must be sure that coverage is offered to at least 98% of all eligible employees. Now, we recommend that employers offer to 100% of all their eligible employees. The 98%, which is also another safe harbor that you can check on the 1094 form, is just in case there's any error or omission, so allowing for that 2%, but you definitely want to offer to all your eligible employees. Confirm that the EIN and company name are the same to what the IRS has, and we'll explain a little bit that further down the road. But yes, if the company name is different in any shape, way, or form, and the EIN is not correct, Well, that submission is not going to be accepted by the IRS. So at that point, it's obviously a problem because now there's a red flag on their part. We have to go back to the employer and ask them to get this information. And by that time, it's probably already mid-March or close to the end of March, and we don't want to risk e-filing the information with the IRS after the March 31st, 2019 deadline. So very important. Same thing with employees' information, basically names and social security numbers. We will explain also a little bit later in this presentation how to procure that information. And same thing, it has to be accurate and it has to match what the IRS has in their databases. And not have, if they don't match, the IRS will produce what is called an IRS error notification, which signals that there's a problem somewhere, either in the name or social security number. Unfortunately, the coding or the way the IRS presents this error is not specific. So at that point, the employer will have to go back to the employee, chase them around, try to get the information. And again, being that there's deadlines and being that timeliness is a factor, is very important to get that information right in the first place. And again, pay special attention to accuracy of all submitted data and to timeliness in providing that information to us. Of course, the IRS has its own deadlines, and we have our own internal deadlines if your clients decide to go with us, in order to guarantee that we have time to review the data, process it, to produce accurate Form 1094 and all the 1095s. Now, company. The company is company part of a control group? Well, again, it could be a little bit difficult for the HR department to even get that information, but it is important anyway. So you must determine that. And based on what the ACA puts forth in terms of the ownership structures, what includes relationships such as siblings having ownership in another company or spouses and so on, it can get a little convoluted. So it's strongly advised that legal counsel is consulted in order to determine if the company is, in fact, part of the control group. Because if we e-file companies separately without acknowledging that they're part of a control group, the company or companies can be penalized. And remember, and also always advise your clients that the total number of full-time or full-time equivalent employees from all companies from a control group is what determines if a company or the control group must file. In other words, if there's a company with 45 full-time or full-time equivalent employees and another one that has 5 full-time equivalent employees, and by themselves, technically, they don't have to file. But if they're part of the same control group, because the total is 50 or more, then they have to report. So this is lost sometimes in some companies, so you must remind them of this. So you might want to take note of what is on this slide. The company data, name and EIN. So as mentioned, these must match what the IRS has in its databases. So part of our procedures here at Diversified Administration is to ask our clients to submit to us an IRS verification document or any document from the IRS that contains the name of the company and its EIN. And we will work and we will process all the information using that exact name. If a company does not have those documents, that were misplaced or whatever other reason, they can always contact the IRS to their especially tax line, which the number is there, 800-829-4933, and request an EIN verification document. The Typically, they will say that they'll mail it out. Please advise employers to not agree to that, because if they mail it out, it's going to take a month or more to get to them. So what they should do is ask them to fax it immediately, so the delivery will be immediate. And just a reminder, the IRS does not email that information. So again, asking them to fax, even though it could be a little bit outdated for the younger generation, is something that is more efficient in this case. Then we ask employers that once they get that document to use the name exactly as it is on that IRS verification document. And of course, we will ask them to send us a copy of it. Something to have in mind. Companies have their names. They come up with a name, they write it down, and sometimes those names contain certain special characters. Well, the IRS databases only accept two types of special characters: hyphens and ampersands. Any other special character is not accepted. Commas, periods, dollar signs, any of these that are listed here will not be accepted. Interestingly enough, in some cases we've seen that some names, for whatever reason, are typed and they put two spaces instead of only one between words. Well, if the IRS has the name with two spaces, well, the name that the information is going to be submitted under must also have the two spaces. And vice versa, if the IRS name has only one space, and for whatever reason the name is submitted to us with two spaces, the filer will not be accepted. So it seems a little bit outlandish, but that's how specific the IRS likes to be. Another point is that foreign accent or tilde letters are not accepted. So ñes, like the one that's listed there, any accents or tildes on any other kind of letters will not be accepted. So I put an example here, Joe's Barbecue. Now, this is a made-up name. If it's similar to anybody's name out there, it was not intended. So we have Joe's Barbecue, BBQ, and Salads Incorporated. The first here, the one that I just read, will be obviously the one that typically we'll see written as the name of a company. But it has an apostrophe. It has commas and period, a comma and period. So the IRS will most likely have the name as Joe's with no apostrophe, B dash or B hyphen Q, because hyphens are accepted. The ampersand stays because it's also an accepted character. Salads, no comma and no period. So this would be the name that we will use to submit the information. But of course, again, we have no way of knowing unless we have that IRS verification document. So very important for us to get it. Similarly, the employee data, name and social security number. And again, you might want to take note of what's in this slide. So even though it's really the individual's responsibility to know how the government has their name written, still the IRS places the burden of providing that correct information to the IRS on the employer. So again, the name and social security number must match what the IRS has in its database. The employee, of course, can contact the IRS to confirm their name and social security number. The IRS customer service number is there, 800-829-1040. And it might be quicker for the employee to go to the IRS website and find a local office. And remember, the employer cannot do this on behalf of the employee. We found sometimes we've been questioned about this by employers that say that their workforce doesn't speak English. So they ask if they can call, and they've tried calling. And the IRS has answered that no, they cannot answer. They cannot give that information unless it is the actual employee calling. And of course, it's sometimes difficult. Then the employee doesn't call, and we don't get the right information, and that can be a problem. Always have in mind that for self-funded plans, we need the dependent data, which could cause a problem in getting that information, especially if an employee was working at the company and was covered, and it's his or her dependents were also covered, and suddenly the employee termed isn't at the company anymore, and you can't get a hold of the employee. Still, you must do your due diligence, and we'll explain that in a little bit. Another way of trying to find out if the name is correct is cross-referencing the information you might have in other documents. For example, W-2, a social security card, passport, driver's license, because sometimes we found that it's something just a typo when the information was entered into the sheets that are submitted to us or into the system, and they figure it out right away and they correct it. And this is important to be proactive about it, to not get those IRS error notifications that we will receive on behalf of the employer after submitting the information or e-filing the information. So if there's any doubt about a name, we will suggest the employers to be proactive and start looking at this before submitting the information to us. Sometimes it's not going to be possible for the employer to get that information. Again, the employee might not be working at the company anymore, or the employee might say that, no, this is the information, that's my name, and they called, and the IRS has acknowledged that they might have incorrect information. So it might be that the employee will insist that the information is correct. So in those cases, there's nothing to do. But still, the employer must prove due diligence. The IRS does not give any indication, any guidelines on how to prove due diligence, but benefits industry standards call for to try at least 3 times and document each attempt. Of course, emailing is easily documented. If you send a letter to the last known address, you can always send it certified or accused receipt. And if you call to the last call, depending on your local legislation, you might be able to record a call, although we don't recommend that, but you'll need at least to document that call and take notes in order to prove to the IRS that you did your due diligence if they ever knock on your door. A special note for Latin names. And they can be problematic. And this is not only Latin names, it could be names from other nationalities that have a different individual naming structure. In Latin countries, there's typically a first name, a second name, the father's last name, and the mother's last name in the name. So we've created this example. Again, this is a made-up name. Any similarities, it's a coincidence. So we have Luis Alfonso, which will be either a first name, composed first name, a first name, a second name, and then you have Diaz Fernandez, which will be the father's last name and the mother's last name. So this individual, when this person migrates to the United States and then starts doing his or her paperwork, they sometimes, because the names don't match the different areas, that means the first name, middle initial or middle name, and last name. So sometimes they get confused, and they will eliminate their second name and mother's last name and just put Luis Diaz. But they will probably want to keep both last names. So either the last name, they'll put Diaz Fernandez as a composed last name, or use Diaz as a middle name. And Fernandez will now become their last name. And as you can see, it's different iterations of this, and it can get very confusing. And then you get into hyphens, because now Diaz Fernandez has a hyphen when before it could have not had it. And then you have that in Latin culture, like similarly in English, you call Roberts, you call Bobs. Well, Luises can be called Luchos in Spanish, and a lot of people go by that name, and that can complicate things also. And then to add to this convoluted situation, the same employee could have registered their name differently with different agencies, or different agencies might have taken the name differently. Remember that many people do not, when they first register, don't know or are not familiar with the U.S.'s naming convention. So when they're asked about a middle name, for example, well, they might assume and put whatever name they believe translates to be the middle name. That adds to all kinds of confusion. So you must be aware of this, because you must ask the employee. Of course, you ask them for their name. They'll give you a name, but it's very important to always compare the name that they put on their application for work with their documentation and verify that from the beginning in order to not run into troubles later on. Similarly, as with the company name, the only special character allowed are hyphens. Any other are not. This is especially important, again, for names that have hyphens, accent, or tilde letters. And we put an example here. Again, this is a made-up example, and any similarities with living people is of total coincidence. DeAndre Smith Jones III. Apostrophe will not be accepted. That E with an accent will not be accepted. The hyphen will, and the 3 will not. It's the 3. The IRS actually doesn't put forward any explanation about numerals, but it does give an example in which it shows that an example where there was a 3, a number, it was translated to Roman numerology. So in other words, DeAndre Smith turns into be Dandre without the apostrophe. Smith Jones stays the same because a hyphen, again, is an accepted special character. And the third becomes 3 capital I's. Again, very important to have this in mind when submitting the information to the IRS. So, if incorrect information is submitted, well, first, if the incorrect information is regarding the company name, the submission will be flat out rejected. So that will not produce an IRS error notification. It will just not be accepted, and we will receive through our computerized systems the acknowledgement of that, and will inform the employer to make the necessary corrections. Once that hurdle is passed and the information is submitted, if there's any incorrect information regarding the employee's name or social security number, that will generate an error notification. Now, we don't want our clients to receive this error notification because it's a huge red flag for the IRS. And being that the IRS is hungry for money, they're definitely going to be scrutinize them even further. So, in order to avoid this, please follow the instructions we mentioned before about names, company name, and employee names. In addition, remember that for self-funded plans, this also applies for dependent information. So, a quick explanation. Error notifications are bad. I mentioned the company name. Here, the entire company's submission will be rejected. So, the attempted submission will be recorded. So that might help if, for whatever reason, the filing is not accepted. But this could prompt penalties because of submitting or actually not submitting correct information. The employee name and social security number, or the dependent name, social security number, or date of birth. The little note here, again, for self-funded plans, when a dependent's social security number is not available, you must use the date of birth. This usually happens with newborns that haven't received a social security number yet, and it will be acceptable to put that individual's date of birth. So if there's incorrect information, the employee's record will be rejected. The information will not be delivered if the social security number is incorrect. So from my experience, the only difficulties or only corrections that we've seen or incorrect social security numbers that we've seen is because of typos. So typically that's relatively easy because we get the error notification saying this is not being accepted, and we go back to the employer and we say, hey, it wasn't accepted, get us a right social security number. They get it, and again, it's usually a typo. We resubmit it, and there's usually no problem regarding social security numbers. But if the name is incorrect and the social security number is correct, the submission will be recorded. They'll say, okay, you submitted this information incorrectly. But they'll record it because, again, the social security number is the main piece of information. But however, a penalty for submitting inaccurate information may be imposed. The employer will have the obligation to try to get the correct information and resubmit it. Like we mentioned, you have to try at least 3 times. And there are certain recommended guidelines to comply with this, and as we have mentioned before. Now, the employee, again, when we receive the error notification and we send the request for the correct name to the employer, well, the employer, again, might have difficulty in getting that information. So, but they get it. They get new information. They spoke with the employee. The employee told them, hey, yeah, I mean, there's a hyphen that I missed here. Okay, here's my name again. And we resubmit it. And that information is still incorrect. The IRS will generate another IRS error notification and will have to go back to the employer. That now will have to go back to the employee and tell them, hey, the name that you gave us is not what the IRS has in their databases. Please find out what's happening. And the employee might drag his or her feet and not do it on time. Now, there's no specific date that the IRS says that the information has to be submitted by. But we at Diversified Administration allow up to 3 submissions, meaning that we'll receive 3 IRS error notifications, the first submission, and then 2 IRS error notifications in addition to that to make corrections. Because at that point, it will be assumed that the name is definitely incorrect, that there's no way of getting the correct information, and of course, we have to stop at one point. Typically, the cutoff date, the recommended cutoff date, will be the end of that fiscal year, that calendar year, fiscal year for individuals, which will be December 31st. But again, we won't recommend that. We always recommend to try to get that information, do your due diligence, try at least 3 times, and document each such attempt. What is worse than an IRS error notification that puts your company or the employer's company in the IRS's sights? Well, IRS letter 226J, because this is actually the letter that assesses penalties for, again, inaccurate or non-compliant information. So when are these triggered? Well, these are triggered when at least one eligible full-time employee or full-time equivalent employee was allowed a PTC, which is a premium tax credit, which is usually requested through the marketplace. Then the IRS checks the e-filed ACA forms for that the employer submitted for that employee. So if the employer got the premium tax credit and the the then the IRS is going to say, okay, I'm going to look into this person's employer. They look into it, and they find that, yeah, the employer did not offer compliant ACA compliant coverage. Then the employee will continue to have his or her tax credit, but the employer will be penalized for, again, not offering coverage or not offering compliant coverage. If none of the employees went and got a PTC, premium tax credit, so there will be no trigger. So even if the employer did not offer a compliant plan, as an example, then there will be no letter 226J generated. But of course, we are not suggesting that an employer does not offer compliant coverage. You should, but be advised that if an employee goes to the marketplace, even and receives a premium tax credit, even deserved or not, that'll automatically trigger that the IRS looks into that company's filings. And we're not talking only about ACA filings. They will scrutinize everything. So you have to be very careful. So the IRS reviews the e-file 1085s to find all eligible employees for the same employer that might have not been offered coverage and any other inaccuracy to penalize. Then the IRS letter 226J is sent out to inform the employer of a proposed ESRP, which is the Employer Shared Responsibility Payment. And this has been calculated based on the penalties that were already informed for the 2015 plan year, which is for the year that these IRS letters are going out. And I believe that was $2,060 per year, which comes down to be $173.33 per month per employee that the employee did not receive, was not offered ACA compliant coverage. Be advised that there's another penalty that the 226J does not address, which is the Part B penalty that will be for those cases in which coverage was not offered at all. So that's still to be seen. It's supposedly those will start to come out already. They should have started to come out technically. We haven't seen none yet. But apart from the 226J, there might be another letter assessing additional penalties for those companies, again, that did not offer coverage at all. When the from letter 226J is received, it'll come with all kinds of forms and additional letters. Form 14764 is the response form in which the employer either agrees or disagrees with a proposed ESRP. And I put it in bold letters here in red. We emphatically recommend that no response is given until you, the employer, has consulted with an ACA professional. The problem is that the IRS only gives 30 days to respond. So sometimes that letter is received, it's opened a week later, whatever the case may be, and then the HR person sees it, doesn't know what to do, sends it to higher up, that gets lost in their paperwork, and suddenly 1 week before the deadline, they find out that, oh, we have to respond to this some way. And they check, obviously, that they do not agree with the proposed penalty, but they fail to send the documentation that proves their case, or fail to submit correctly corrected forms. And at that point, the IRS will come back with another letter stating that this is this is now, not the proposed, this is your penalty you have to pay. And so we don't want that to happen because penalties are pretty steep. The smallest that I've seen was close to $30,000, and the biggest that I've seen was over $500,000. And we do know that they are Letter 226Js assessing penalties as high as $2 million. So even though the IRS had said, or the government had said at that time, there will be some leniency, I haven't seen any leniency. So because of $500,000 penalty, for me at least, is not lenient. So this is an example of Letter 226J. Of course, the information for this company has been blurred out, and this is the one that I was mentioning. This is the one with the smallest penalty that I've seen, and this was for $29,119.96. And this is obviously scary for anybody that opens it. The amounts that we've seen in the hundreds of thousands all the way to $500,000 can effectively disrupt a company's operation. So very important that if this is received, to contact a knowledgeable party such as Diversified Administration, and we can actually evaluate and see a good way of answering to this letter to either minimize or completely eliminate the penalty. So in order to avoid Letter 226J, avoid IRS notifications, and all those things that nobody wants, so we offer our ACA reporting services for 2018. And very briefly, how it works is that we sent out our data gathering sheets to our clients, which is basically a Excel sheet that is very easy to understand. There's no code calculation for the employer. They just have to put readily available information that they can just copy onto our sheets. Then on our end, we have back-end macro automation that we run. It's actually a Visual Basic program that runs through these sheets to detect any incongruency or any mistakes. So we run through all those sheets through that. At the same time, and because we have an ongoing conversation with each one of our clients, we can detect any special circumstances or any questionable information, and either find a solution to make it, to clarify that information in order to produce accurate codes, or we can actually see to put some sort of explanation or try to find a solution in order to not have that information flagged by the IRS when it's submitted. Once we have those sheets run and all the information is correct, we have our proprietary data analysis and processing software. What we do is we feed the information on those sheets into the software, and what this does, it reviews the information again, following all the guidelines, all the rules, and so on and so forth, to detect anything that we might have missed in the first run of revisions. And finally, if everything's okay, we will send the results to the employer to review, and just then, if everything's okay, we'll proceed with submitting everything for first distribution, meaning that we will mail the 1095s to all recipients, to all those individuals or employees that will have to receive one. And then we will submit that information, e-file that information with the IRS by the current IRS deadline of March 31st. So we have two sheets. The 1094 employer sheet, which has to do with the company's information. So let me show you very briefly how that looks. Again, Excel sheet that has company's information in the first part. Also, the signer's information would be the person whose name will appear on the 1094 and the person the IRS will reach out to if they have any questions. Then we have a section where you will enter the plan or plans. If it's a calendar year plan, you will only use the first section. If it happens to be a non-calendar year plan, you use a following section. And in the cases in which an employer had short plan years, meaning that they'll have more than one plan or consecutive plan during the year, then you will use the additional sections here. Now remember that we want to report the individual only cheapest available plan that is available to all employees. We do not care about silver or gold plans or any additions to any plan. Again, just the basic plan. And that's the information you'll enter here. And again, this was our employer sheet. The employee sheet, the 1095 employee sheet, is also an Excel sheet. It will contains the employee census, employment and coverage information, and dependent information for self-funded plans. That's why we put when applicable. Very quickly, so you have an idea how it looks like. Again, Excel sheet. We have a section here to enter the company information as well the contact, and automatically advises that the information is missing. The green section is census information about the employee, name, social security number, address. The following blue section has to do with employment and coverage information. Gray section is for status changes and termination information. And then there's more. The same section repeats itself several times, but most of the time employers will only use a first and second section because there'll be rehires and people that change from full-time status to part-time status or variable hour status. And so that will probably happen once or twice in a company, but there are certain industries that have a high turnover rate or are very seasonal that constantly hire and terminate employees, or that constantly change from a full-time to a part-time status. So to account for those situations is that this same section repeats several times, but doesn't mean that you have to fill them. You'll just have to fill the ones that pertain to a particular situation. So those were our data gathering sheets. And again, we have a enrollment package that if you have employers, you have clients that are interested in learning a little bit more about our services, please just request it to us or from us. The process is very simple. We send out those sheets to HR or the party that we'll be dealing with at the company. They will fill the sheets, we'll process it. If our system detects any incongruency or a mistake, we'll send it back for review. They'll resend it, and this process will repeat itself until the information is correct, and we were able to mail out all the 1095s to all recipients, to all eligible employees by January 31st, and then e-file that information with the 1094 by March 31st, 2019. Of course, the IRS may grant extensions, but as of now, these are the IRS deadlines. So that'll be it. Again, if you have any other questions about this webinar, please feel free to call us at 954-983-9970 or email us at info@div125.com. If by any chance you happen to have any questions right now, please feel free to write them down in the chat window, and I'll do my best to answer them now, since we have a few minutes before 11. Please also be aware that we are also hosting a Letter 226J webinar. The first one will be tomorrow afternoon. So if you have not signed up to one of those webinars, please do, following the same link you used to register for this one. And I see no questions in the chat. Hopefully that's because my explanation, my presentation was pretty complete and accurate. So again, I thank you all for attending, and have an excellent day. Thank you.